I'm also full of
Okay.
Good afternoon, everyone. Thank you so much for joining us for lunch today and for this wonderful event. For those of you that do not know me, my name is Rosa Salora and I'm Associate Dean for International and Comparative Legal Studies here at GW Law School. I am thrilled that you have joined us today, and I have the honor of introducing our main speaker today. I don't think she needs an introduction. I think many of you know her. She's working on wonderful scholarship, especially in the area of international criminal law. So it's going to be fantastic to hear what she's working on today. And as you know, she's also very, very actively involved with international and comparative law program, and I feel very privileged to be working with her as well. I just wanted to give you a bit of a bio of her work. It's a very long bio, but I'm gonna try to, do this in a brief way so she has time to present her paper. But she is an alum of the law school, as you all know. She's also working right now as a visiting associate professor and fellow for a program, International Comparative Law Program. And she actually, when she was at the law school, she did everything. So I always tell students that she's such a wonderful resource, of information and experiences of what you can do, with an ICL degree. She's a graduate of honors from this law school with a concentration in international comparative law. She was also a Thurgood Marshall Scholar, an executive articles editor for the GW International Law Review, and a member of our Jessup International Law Multicourt team. And she's also coaching the team this year, which is absolutely fantastic. She was also an attorney, a student attorney for the Global Network Initiative as part of the International Human Rights Clinic, in addition to working as a research assistant for Professors Sean Murphy and Ed Swain. She also did the Oxford program when she was here, at the law school, and also she served as a law clerk on the Special Matters Unit Fraud Division of CACHI International. The title of her paper that she's presenting today is Reparations for All, a Separation of the Trust Fund for Victims from the International Criminal Court, a good idea, which is, of course, a very timely and relevant topic today. Without further ado, I leave you with our speaker, and thank you, Leah, for everything that you do for our law school and for the International Comparative Law Program.
Thank you, Dean Solorio, for that very, very kind introduction. And thank you all so much for coming today. I really appreciate you being here to hear a little bit about my research. I will say just from the outset that this is very early stages. So it is in flux, it is changing, it's progressing. Even just in the past few days, I think I've decided that the title might change to say Assistance for All rather than Reparations. And that will become clear as I go through my presentation, why I'm focusing a little bit more on the assistance rather than the reparations. But just to get started, I do want to kind of offer an introduction to go through what my research questions are, what I'm focusing on as I'm doing this research. So initially, I wanted to figure out how do we achieve the most widespread victim-centered accessibility to the assistance provided by the Trust Fund for Victims at the ICC. And in trying to determine how we achieve that, there are some other questions that come up that need to be answered. First and foremost, is how the TFV functions at the ICC even an effective mechanism in and of itself to provide widespread and accessible assistance? Along those lines, would the TFV be more effective as a body within the United Nations rather than the ICC? Or in the alternative, would it be a more effective body as if it was entirely independent of the ICC, of the UN, just functioning on its own? So these are the main questions that I'm thinking through as I'm doing this research. For the students in the room and for people who are less familiar with victims' rights and why we're even having this conversation, I'm going to offer a very, very quick, high-level overview of what victims' rights are, what is this right to redress that is talked about, and hopefully this will provide enough background for you to understand the rest of the presentation. So essentially, the right to redress can be traced back historically for centuries. There really is not a single society in at least modern history that we can think of that does not have some form of a right to redress. Most societies with a legal system or with a quasi-legal system have this understanding that redress is something that victims are owed. In the 1700s and 1800s, gradually there's more of an emphasis and focus on retributivism. I always have struggle with that word. And then finally, in World War I and World War II, we kind of see more of a turning point in international human rights law, in international criminal law, and of course in the recognition of victims' rights. So during that time, we see international law focusing more on the rights that individuals hold on their own rather than just having international law apply to states as bodies themselves. So conventions are drafted and signed, which place responsibility on states to protect individual rights. Examples being the Geneva Conventions, the Genocide Convention, the list goes on. And so there's a great deal of public support at this time for this notion of redress for wrongs, and this acknowledgement of the fact that these atrocities and these commissions of violations of human rights are unacceptable. So we have this public support. We're no longer really recognizing immunity for states. We are holding states accountable for either commission or omissions that result in the violations of these norms and these rights. The eventual push for greater compensation was resulting in states pulling away from wanting to push for victims' rights. But regardless of that, we do see that we're making progress here. So in 1985, finally, we have the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. And this kind of sets forth a comprehensive detail concerning a state's duty to provide a remedy to individual victims. And this is really focusing on victims of domestic criminal law and the state's responsibility to provide compensation for those victims. And then in 2005, we see these basic principles come into being, and the full title of these basic principles are the Basic Principles and Guidelines on the Right to a Remedy and Reparation for Victims of Gross Violations of International Human Rights Law and Serious Violations of International Humanitarian Law. It is a mouthful, it takes 2 lines, but that is what we have resulting from a UN General Assembly resolution in 2005. And the goal of this resolution and of these guidelines is to recommend to states that they take these into account and that they promote the respect and thereof and bring them to the attention of members of the executive bodies of government, meaning states should filter these down into their law enforcement officials, legislative bodies, their judiciaries, and also promoting these to victims and their representatives, human rights defenders and lawyers, the media and the public in general, because the goal behind these is really to ensure that everyone is aware that these rights are something that they are very much capable of fighting for and that they are entitled to. So the guidelines were drafted with this victim-based perspective. They were essentially meant to provide for mechanisms, modalities, and procedures and methods for the implementation of what they considered were already existing legal obligations in the international community. So with the goal of maximizing positive outcomes and minimizing the diversity of approaches that could result in uneven implications for these victims' rights, they published these guidelines, and Article 7 lays out what is listed here as a victim's right to remedy. So essentially, the rights that victims have at this moment in time is a right to access to justice. This really is just that states have an obligation under international law to provide some access, some pathway to justice. And then they also have a right to adequate, effective, and prompt reparation for harm suffered. This can come in many, many forms, and this is also owed for the commission or omission resulting in a violation. It's also owed on behalf of individuals who violate rights. So there's both, we're seeing now the concept of states owing responsibility to individuals for these rights, and also individuals owing responsibility to other individuals for these rights. So this can come in many, many forms. We have just the basic categories here. Restitution, which can come in the form of the restoration of family life, of citizenship, the return to one's residence, things like that. Then we have compensation, which is typically used in the cases in which you can find the economically accessible damages. We have rehabilitation, which is medical and psychological care, legal and social services. Satisfaction is always discussed as more of the creative option, and that comes in the form of public disclosures of truth, public apologies, commemorations, other such tributes to victims. And then lastly, the guarantees of non-repetition would be legislative reform, protections for media, protections for human rights defenders. So this is that second right, that is how that is achieved, and that is what we are laying out in these guidelines. Lastly, which is kind of in line with the goal behind this General Assembly resolution, is the right to access relevant information concerning violations and reparation mechanisms. So states can't hide the ball. They need to ensure that victims and the public, the wider public, are aware that they have the right to these different reparations, to have access to justice. So it's a very high level overview of victims' rights and why we're having this conversation and why this is important. So another little bit of background, what is the Trust Fund for Victims, since that is what this presentation is about. First off, what is the ICC? The International Criminal Court is an intergovernmental organization and an international tribunal that was established by the Rome Statute back in 1998, entered into force in 2002. The ICC, in particular circumstances, I won't get into the jurisdictional requirements here, but essentially they can prosecute individuals for the crimes of genocide, crimes against humanity, war crimes, and the crime of aggression. It should be stated that the ICC has come a long way in protecting victims' rights and providing for them. They have multiple articles in the Rome Statute that lay out various methods of their involvement. They are permitted to submit observations to the court, which is essentially stating that they have that a crime has been committed against them. They're allowed to submit that. There's a portal that you can access online to do that. There's also requirements in the Rome Statute that the victim's rights and the victims are taken into consideration during various points in the investigation and the trial process. There's also the Victims and Witnesses Unit in the registry, which is like the administrative wing of the court. And then, of course, what's important for us today are Article 75 and 79, which establish the right to reparations and the establishment of the Trust Fund for Victims. So Article 75 essentially outlines that the court has the ability to establish principles relating to reparations to or in respect of victims, including restitution, compensation, and rehabilitation, and that they are also able to determine the scope and extent of damage to determine what these reparations should actually look like, and also have the capability of ordering reparations against convicted perpetrators. And then Article 79 says that a trust fund shall be established by decision of the Assembly of States Parties for the benefit of victims of crimes within the jurisdiction of the court and the families of such victims. So that is how we arrive to where we are today. And now we're going to look at a little bit of how the Trust Fund for Victims operates at the ICC. So essentially it operates with two mandates. The first mandate is known as its reparations mandate, and this is the requirement for the TFV to act kind of as an intermediary in implementing the court-ordered reparations issued against convicted perpetrators. So ideally, this would be through funds provided from the convicted person. However, what has happened thus far is that all the convicted perpetrators with an order of reparations against them have been declared indigent for the purposes of reparations, and therefore there has been, in practice, the trust fund and the board of trustees, which runs the trust fund, has determined that they will supplement these orders with their own budget, with their own money, which comes from voluntary contributions from states parties and other individuals and private organizations, and they will front this money to the victims for the reparations because they're not going to get that from the convicted perpetrator. That's not exactly what was intended, but that is the reality that we're working on. For instance, the Lubanga case, that is exactly what has happened. The trust fund has stepped in and they have provided the reparations out of their own funds. The second mandate, which is the one that I think I'm gradually focusing on more and more, is known as their assistance mandate. And this is essentially that they are permitted to provide assistance to the most vulnerable victims, and there is a leaning towards providing this assistance to victims of the most severe forms of violence, which typically comes in the form of sexual and gender-based violence, violence against children, things like that. And as well as the families and communities of these victims are all kind of included in these assistance projects. So how do these programs work? Essentially, the Trust Fund for Victims, out of its voluntary contributions that it has received and the budget that it's working under, will give this money to implementing partners in the local communities. And so the implementing partners are the ones who are actually working in the field. They're the ones boots on the ground, doing the work, interfacing with the communities and the victims. The trust fund is working on the funding and the logistics. And so really this is all from a procurement process, is how they find these implementing partners, and then that is how these projects come into being. There are several going on right now, just to give you an idea of the progression of these assistance programs. The program in Uganda started in 2019 with 6 implementing partners. As of 2021, it had 29. So there is a drastic expansion of these programs gradually as they really understand the full extent of what's needed in these communities. Another program that I can give as an example is the Central African Republic. Their program started in 2020, and they are focusing on providing medical care for pathological diseases, access to food security and nutritional support, access to psychological care, access to education for dependents and provision of school equipment, housing for homeless victims, and access and assistance with income generating activities and self-employment. So that's the full extent of what they're doing in that specific assistance program. So they really do have a far wide-reaching capability of engaging with these communities and providing this assistance. Another aspect that has to be taken into consideration, that is something that I haven't been able to do a completely deep dive into yet, but I do want to just state the importance of this, is to understand meaningful victim participation. What is that? So we really have to consider the accessibility of the resources that the TFV provides, but also taking into account the role that victims play in decision making, as well as the degree to which the outcomes and support provided to the communities are victim centered. And that means taking a look to see the empowerment and entitlement in political processes. Are communities involved? Are victims consulted? Are they consulted at the design stage when they're actually trying to figure out what are these reparations schemes, what are these assistance programs going to look like? Or are they just consulted at the back end when they're actually being distributed? And then also kind of taking that another level, are the implementing partners and the people working for these partners familiar with the cultures that they're dealing with? Are they familiar with the actual circumstances that resulted in them being victims? All of these things are really important to take into consideration. Another thing that I'll note is the perception versus experience delineation. There is, I think from the outside, there can be this perception that it is very victim-centered. These victims are incredibly involved, obviously, because we are providing them with things that they need. But is that the actual experience of these individuals? That's something that needs to be looked into. The last thing I'll note here is the potential negative consequences of victim participation. That is not something that's discussed very often, but it does need to be considered when we're figuring out whether or not it's meaningful. So there's safety and security concerns for these victims. There are political pressures that they're dealing with. There's also continued discrimination that victims face from their communities and the communities around them, and also the trauma that they are still processing that can potentially prevent their engagement from being a healing process or from feeling empowering. So that has to be taken into consideration as well. And then, like I said, their participation in the design phase is key. So is it actually starting in a meaningful way then, or are we not seeing it until later on in the process? Again, not something I've delved into too deeply, but it is something that's kind of the through line in this research as well. So just to give kind of a very broad description of some successes and drawbacks that I have noticed in this research. So First off, the ICC's TFV has had several major successes. I will say that its ability to operate independently of the court is a huge win. So it was able to kind of, the first time that they entered into an assistance program, get this right out of the bat. They were like, we are not going to wait for you to start a trial. We are not going to wait for you to say that this is where we are permitted to operate. They are allowed to go in and figure out where they want to provide this assistance, get this started prior to a prosecution, prior to even necessarily an in-depth investigation. They're operating independently of the court, which is great. Another thing is that this is a major improvement over the ad hoc tribunals. So the International Criminal Tribunal for Yugoslavia and the International Criminal Tribunal for Rwanda really only engaged with and viewed victims as witnesses. There was no real discussion of compensation and reparation at the ICTY and ICTR. There was no existence of an assistance program in any way, shape, or form put forth by the tribunals. So this is a huge win that the ICC has been able to come this far and has the Trust Fund for Victims operating in this way. Lastly, the achievements of their ongoing assistance programs are great. So they have current programs going on in northern Uganda, the DRC, Cote d'Ivoire, Central African Republic, Mali, Georgia, and Kenya. Some examples of things that they've been able to achieve: they are really providing a lot of prosthesis for people in Uganda, which is making a drastic impact on their quality of life. A specific example that they include in their annual report was that for a woman in Uganda who was abducted at the age of 14 by the Lord's Resistance Army and forced to undergo rapes, beatings, and was enslaved into the militia, they were able to provide her with psychiatric treatment for PTSD and depression, and this drastically improved her life. She brought her husband into the program, she brought her family members into the program. This was a huge moment for her. And then furthermore, for women in the DRC who became pregnant as the result of rape and then had children to care for when they were able to get out of captivity, these assistance programs have gone in and they have created childcare programs and education programs so that they're able to complete their education and focus on their own healing process while they're doing that, rather than having to care for children. But they're still taken care of, which is another great achievement. However, there are also some pretty major drawbacks to having the TFV at the ICC. So first and foremost, they're pretty restricted in their ability to provide assistance, given that they're only allowed to provide assistance to victims of crimes within the jurisdiction of the court. This means that they can only provide this assistance to victims of genocide, crimes against humanity, war crimes, and the crime of aggression as they are written in the Rome Statute, which doesn't necessarily provide the farthest reaching jurisdiction. And then additionally, they're not able to provide this assistance to anyone who is victimized by an individual who would not fall under the personal jurisdiction of the court. They're very limited geographically in only being able to provide this assistance in what the ICC calls situation countries. And that really just means that these are states parties that have accepted the jurisdiction of the court, and therefore the TFV can operate freely. But that's not every country. If those of you familiar with the ICC, it is very controversial, and not a lot of countries are party. I mean, a lot of countries are, but not every country is party to the ICC. Another major constraint or drawback is the budgetary constraints. So I'm about to talk about some UN trust funds. All trust funds are funded by voluntary contributions. That is just the reality of how these things operate. So that does provide some drawbacks, but when you think about all of the things that they do, in 2020 their budget was $3.1 million, which is not a lot, and that really restricts their capability of providing more far-reaching assistance. Additionally, they've expressed, and through how they have conducted themselves with the Lubanga case in providing reparations out of their own funds, they now are kind of expected to maintain part of their budget in the case of a reparations order, so that way they are able to fulfill those reparations orders for indigent defendants, even though technically that entire budget should be going towards the assistance mandate. they're prevented from allowing it to fully operate in that way. So out of $3.1 million, not all of that can be put towards the assistance mandate. So really it's less than that. So to provide some alternatives and to see whether or not this would be something that could feasibly be put towards the United Nations, we actually have two really great examples of United Nations trust funds. So I'll talk through those a little bit just to kind of give you an idea of what this might look like. So the UN Voluntary Fund for Victims of Torture, this was established in 1981 by a UN General Assembly resolution, and the basis for this comes from the Convention Against Torture, Article 14, which provides for the fact that states are expected to provide reparations for victims of torture. And so this trust fund gives directly to help, they give to civil society organizations and other groups that then help victims of torture and their families. So it's similar to the Trust Fund for Victims in that they have these implementing partners that are actually the ones doing the work on the ground. So this comes in the form of grants, the donation, again, voluntary contributions, mostly coming from states, private entities, and individuals, same as the Trust Fund for Victims. And through these grants, groups are able to provide medical, social, and legal assistance to torture victims, and they also can help increase the capacity of these civil society organizations that are doing the work on the ground. So there is that additional benefit. Again, operates under a board of directors, similar to the Trust Fund for Victims. So we do have this very similar operating mechanism. Some examples of what they've been able to do: they have provided funds for legal assistance in universal jurisdiction cases and other types of legal support. They have offered subsidies for rent, paying for language classes, and other medical and psychological assistance. So they really do have, and that's very limited examples. They operate much larger than that. And then we have the UN Voluntary Trust Fund on Contemporary Forms of Slavery. What are contemporary forms of slavery? Children in armed conflict, debt bondage, forced and early marriage, sale of children, sexual slavery, the list goes on, but that is the general idea of what this fund is meant to assist with. And so the purpose of this fund is to assist representatives of NGOs dealing with issues of contemporary forms of slavery and to extend humanitarian, legal, and financial aid to individuals whose human rights have been violated as a result of this. The major difference between this fund and the other two that we've talked about is that in addition to providing money to representatives of civil society organizations and other NGOs, they are actually able to provide money directly to individuals as long as the Board of Trustees has deemed that they actually have been a victim of a contemporary form of slavery. But that is a unique aspect to this fund. So you don't have that money going to individuals at the Trust Fund for Victims or at the Voluntary Fund for Victims of Torture. They provide similar services. They support for substance abuse. They have housing support, physical and psychological medical support, legal support. So it is similar manifestations, but they do operate a little bit differently because of that ability to give money directly to individuals. But these are the examples. This is potentially what the Trust Fund for Victims would look like if it was part of the United Nations rather than the ICC. I'm very briefly going to touch upon what would this look like as an independent body. When I started this research, I was convinced this was going to be the answer. No, I don't think that anymore. So really, what would this look like? It would be another intergovernmental organization. I just do not think that the international community has the momentum to get behind another IGO. I don't think it would be feasible. In an ideal world, it might be the best solution because it feasibly could have a lot of money behind it. It could have a lot of support. It would have far-reaching capabilities, but I just, based on my research, do not think that this would be the best path forward. So that brings me to my hypothesis. And currently, where I am now, I think that the Trust Fund for Victims would be more accessible, effective, and successful as a UN trust fund, and therefore should be separated from the ICC. Just to provide some very basic examples as to why I think this. So the UN trust funds have been able to provide funds to civil society organizations that operate and several countries where the ICC cannot. To give you an example, Kazakhstan, Iraq, Thailand, Sri Lanka, India, South Sudan, Togo, the Russian Federation, the United States, Turkey, Israel, Mauritania, Nepal, Vietnam, Pakistan, Haiti, Syria. There are many more. So whereas the ICC cannot provide any assistance in those regions, the UN trust funds have shown that they can. So if the Trust Fund for Victims was transferred to the United Nations, potentially they would have a much greater reach in their ability to provide assistance. Other things that I do want to mention, so it's unclear currently if the Trust Fund for Victims at the ICC has the capacity to initiate assistance programs in certain countries where it actually is operating. So as of now, all the assistance programs are in states parties. But the ICC has other ways to access jurisdiction. So for instance, Article 12.3 referrals means that a state that is not party to the Rome Statute can submit to the court's jurisdiction for a certain period of time. Currently, that would be Ukraine and Palestine. We do not have precedent for whether or not the Trust Fund for Victims can enter and start an assistance program in these areas. So that is unclear. Additionally, the UN Security Council can refer situations to the ICC and grant jurisdiction in that way. Not clear that the Trust Fund for Victims would be able to operate in those areas either. Currently, that's Sudan and Libya. And then lastly, what about the countries that withdraw from the Rome Statute? So right now, the ICC is currently investigating and hopefully going to amount to prosecutions in Burundi and the Philippines. However, both countries withdrew from the Rome Statute and are no longer technically parties. The investigations are permitted to go forward because they do still have jurisdiction in those countries for the time in which they were party. But now that they're not clear that the trust fund would be able to get in there and provide assistance. However, if that trust fund was part of the United Nations, arguably they would be able to step in, they would be able to provide assistance. So that is another reason why I feel like it should be separated. Then to discuss some of the budgetary developments. So just to give you an example, looking at 2020, like I said, the Trust Fund for Victims had $3.1 million in their budget. The Fund for Torture was operating on a $10.4 million budget, $8 million of which came from the United States. And the Fund for Slavery, a little bit less, had around an $848,000 budget for that year. So because the U.S. is not party to the Rome Statute, we have not given money to the Trust Fund for Victims. There's a huge push for it. The current Ambassador for Global Criminal Justice, Beth Van Schaack, is pushing for the U.S. to contribute money to the Trust Fund for Victims, but we have not seen that happen yet. Unclear if Congress would support that. So if, however, we pull this out of the ICC, which is so controversial for the U.S., and rather it's part of the United Nations, we have precedent for the fact that the U.S. can contribute money to a United Nations trust fund. So arguably there would be a better chance that they would then be able to contribute money, which would drastically increase the budget of the Trust Fund for Victims and allow them to provide greater assistance in multiple countries. I'm considering whether or not this means we should conflate the trust funds and combine the budgets, or if they should remain separate, something that I'm toying with right now. And in addition to that, I'm also thinking through a couple of other things. So the feasibility of actually separating this is something that I have to think through. So should the TFV's assistance mandate be removed from the ICC entirely, or should we establish this new trust fund with the United Nations that operates in a similar manner and has the similar impact, but is under the United Nations umbrella rather than the ICC? And just kind of potential negative consequences of removing this assistance mandate from the ICC. I'm going to look through that as well and consider whether or not this is really actually feasible. My hope is that it is, because I really do think that this would result in much far-reaching support, but that is where I am now in my research, so thank you so much. And if you have any questions or comments, please let me know. I am very open. Thank you.
I think it's really super interesting, and I applaud your pursuit of this, and also your flexibility as you're kind of dealing with all the political and legal complications of this. So I guess I've got sort of a slightly contrary instinct on this, but I'm not sure of where I land either on this. So I begin with sort of the null hypothesis that states can always supplement the funding for victims through bilateral assistance, right? And that a key variable here is how this will affect gross contributions, right? And we can't tweak the UN mechanism or the ICC mechanism and assume that contributions from states will remain constant, either in the whole scheme of things or through that mechanism, right? It could increase or decrease contributions to that. And so I guess my overall reaction is, all things being equal, additional flexibility would be great. So too would additional funding, however you manage to corral it, right?
Yeah.
But one thing you might lose if you go through the UN route is a way for states to signal, including through financially, their support for the ICC as undertakings, right? And the US is a very complicated example here for reasons you know well, and there's domestic funding restraints that are tricky when it comes to making this contribution. We may have finessed them in Ukraine, we may have finessed them more broadly given the OLC's positions on this, right? But beyond that, I kind of like the aspect that the fund associated with, if independent formally of the court, right, gives a carrot for states to support it, right? It allows them to explain to domestic constituencies, here is a plus for continuing to participate in the court and not withdrawing from it. In the event something goes, awry here, we nationals will benefit from it all, right? Yeah. And it allows a way of kind of signaling how continued participation in the court and acceding to its jurisdiction has a political payoff. And I just wonder if you might lose that a little bit if you do go.
Yeah, that's a very good point. Yeah, something I will definitely have to dive deeper in, because I do think the struggle I always have with the ICC is that the countries that are donating, the countries that are most active they're typically not the ones at risk of falling before the court. And like the ones that are the most likely to join on probably are also not going to be before the court. So it's a carrot, but I don't know how effective of a carrot it is. Yeah, I'm not sure, but that's really great. Yeah, thank you. Yeah.
Whether the assistance can be provided all depends on the mandate. It's not clear if you want to move it to the UN, what kind of mandate you get, who you get to approve it, would it be the General Assembly, and how you find that mandate. What puzzled me about the presentation of the trust fund is you put it forward as it's allowed to give assistance to victims of crimes within the jurisdiction of the ICC, but how do you know you've got a crime within the jurisdiction of the ICC unless there's been a conviction? And you said they give assistance before, and isn't that ultra virus? I mean, how could they, what's their authority to give before there's a conviction indicating that there has been a crime within the jurisdiction as determined by the ICC?
So the argument, I believe, is that you don't necessarily have to have a conviction of an individual, but there's evidence enough that a crime within their jurisdiction took place. And that's why I think it's typically happening in situation countries where they are parties to the Rome Statute. It hasn't happened in these other countries where jurisdiction is more unclear, because in those, we have the territorial jurisdiction, that's not a question, and there's clear evidence on the ground that a crime took place within so a crime against humanity, a war crime, we haven't gotten to the point of convicting an individual yet.
But there's always evidence all over the place that they're crimes, and aren't the accused saying that's not the case.
Depends on their defense, yeah. But it's definitely contentious. Like I will definitely give you that. I think that it's not necessarily cut and dry why that is the way it is, but the goal behind it was to just I mean, these court cases take decades, so to be able to provide
Right,
assistance before,
So are any of the countries that are getting assistance objecting to the court that this is not appropriate because there's not been a conviction?
The countries, no.
Okay.
Yeah. I'm gonna go with Laura, and then I'll work my way around.
Thank you for your presentation. My question is, people in other different human rights coming in and seeking assistance from the ICC, which confines it to those.
So I think that goes back to the previous comment of what would the mandate be when this is at the United Nations. And I think that that would first depend on whether or not we're conflating them. If we're creating a new trust fund that combines all of these, there's gonna have to be a way to make it clear. Something else that I'm thinking about is whether or not earmarking would be permitted, because if that was allowed, then maybe states would in their voluntary contributions say this is meant for victims of torture, this is meant for victims of crimes against humanity. I don't know, I haven't thought through really very far whether or not that would be the best approach, but it could be a way to kind of delineate more where this money is going to go and what it's meant to help. Yeah. Professor Lerner.
Scheme made me think a little bit of, in civil law countries, the practice of having a civil party to criminal cases. And many civil law countries, as you know, there is a civil party, and that party is represented by counsel and can ask for damages and so forth. And in cases where the defendant is indigent, those damages are paid for by a state fund for victims. And it made me think a little bit of that, and made me wonder whether, so with this victim participation involving the trust fund for victims, are victims represented by counsel before the fund or before the ICC?
Before the fund, no. Before the ICC, yes.
Maybe if they're separated, as you say that they are, maybe they should be represented by counsel before the trust fund.
Yeah. That's a very good point. Yeah, right. Currently, that is not how, because they're kind of the implementing partners. I think are playing a bigger role as the intermediary versus the victims taking that more active role, which I think needs to be argued that should be the case, and maybe then having those attorneys involved would protect their interests to a greater extent. Yeah, that's very interesting. And actually, the civil law way that they do it was the reason why it was my inspiration for looking into this. So yeah,
Great.
yeah.
Do you think this fund should be attached to the STAR program at the World Bank that aims to reclaim money that was stolen by?
That's not a bad idea. I've never thought of that. I think that there would be a legality issue there in the fact that the funds in those certain situations might not be directly tied. So that's where like the reparations versus assistance kind of gets a little murky, because the reparations are coming from individuals. But even at the ICC, they have said that the certain factors such as their personal responsibility in the actual crime or other mitigating factors don't play a role in their assessment of reparations. It's only that these victims suffered X amount of damage. So the goal there is really just to put victims back in the place that they were prior to. And in that sense, I think pulling from something like that would be permissible and would be a great achievement. But if you're really trying to have those funds go directly towards the people that it impacted, I don't know that would be, I don't know how much public support would be behind that because of that. Yeah. Questions, Marielda?
For your presentation. My question is, we know that when a case is referred to the ICC, ICC has jurisdiction over countries that are not part of ICC jurisdiction. So my question is, when the Security Council referred these cases, is there any regulation or a way to get more funds?
Not that I'm aware, but that is very interesting, like whether or not they could include in their referral a portion of funds. I don't think that that would go over well, just because a lot of the US, Russia, and China are not members of the Rome Statute, and they are
Yeah,
on the Security
that came
Council.
to my mind when
Yeah.
you mentioned that United States don't offer
Right,
the fund,
right,
but
yeah.
maybe it can be a way.
I think that would be more controversial than them giving money as just an independent state, because then it's like it is earmarked to prosecution, and that's like direct support of what they struggle with the most about the ICC versus a voluntary contribution that was just going towards the fund and had nothing to do with the prosecution. I think that's more likely to be acceptable than having that close tie with the prosecution. But that's a very good point. Yeah. Great. Samantha?
Thanks for your presentation. Really. Regarding the issue of reparations, so you are proposing that the trust fund go perhaps to the UN. So how would the issue of reparations work if it is that the person is convicted and they have funds in some Swiss bank account somewhere, and the court seeks to access those funds, but then the trust fund is at the UN? How would that?
Yes. So my argument is to remove the assistance mandate. So there would still be some mechanism at the ICC to address the reparations mandate that was part of the Trust Fund for Victims, because that I think is so closely tied with the ICC, you can't remove that. And that's why I'm unclear at this point whether or not this should be removed entirely, the assistance mandate, or if we should leave something operating at the ICC, but then create some new type of trust fund that has a broader reach than the ones that we currently have at the UN. But that definitely would still need to remain at the ICC, because if ever there is a day that we get a convicted perpetrator that has money, then they can go forth and give that out to the implementing partners, which would be great.
But then the trust fund will continue to be empty until that happens. When I say empty, it doesn't have as much, well, empty from the convicted perpetrator. Till that
I'm not
happens.
sure that I understand.
No, I'm just trying to see if there's any other mechanism
Yeah.
apart from going to the UN where funds could be deposited for both aspects of the trust fund, but out of the political hands that would assist, that would provide the reparations and will be on a wider scale than it is now.
Yeah, I don't think so. And I know that your greatest issue is that these perpetrators are not providing the money for the reparations, but I think that that is just the sad reality of this taking decades after the fact, and there are some just really unfortunate things about how this process works, that I don't think that there is an alternative beyond kind of what, at least I haven't thought of anything, right? Like, these are the things that I've thought about as solutions to that issue. Yeah, I'm not sure. Yeah. Awesome. Well, great. Thank you all so much for coming. Thank you.
It takes a long time.
Yeah, there's a lot, you know, there's lots of legal.
So I think